Are wills public record in New York? When creating a will, many people wonder whether their personal wishes and financial details will remain private or if they will eventually become public. In New York, a will typically becomes a public record once it is filed with the court during the probate process. This can raise concerns about privacy and how to best protect sensitive information. Understanding how wills are handled under New York law is essential for making informed estate planning decisions. The legalities of wills and public records. A will remains private during a person's lifetime, but after their passing, it usually must be submitted to the surrogate's court in the county where they resided. This filing initiates the probate process, during which the will becomes part of the public record. This means that anyone can request a copy of the will from the court. The document's public nature ensures transparency in asset distribution. Beneficiaries, creditors, and interested parties can review the will to confirm its authenticity. However, not all assets are subject to probate. For instance, assets held in trust or those with designated beneficiaries, such as life insurance policies and retirement accounts, often bypass probate, maintaining privacy. When does a will become a public document? A will does not become a public document until it is filed with the court. While the testator is alive, the will remains private and can only be accessed by those the testator chooses. Upon death, if probate is required, the will is filed, and at that point, it becomes accessible to the public. Some estate planning tools allow individuals to keep their financial affairs private even after death. Using a revocable living trust, for example, ensures that assets are distributed privately without the need for court involvement. How to keep a will private in New York while wills filed with the surrogate's court become public? There are legal strategies available to maintain privacy. Avoiding probate is the most effective way to keep estate details confidential. Some options include revocable living trusts. Assets held in a trust do not go through probate, keeping them private. Joint ownership of property. Assets owned jointly with rights of survivorship automatically transfer to the surviving owner. Payable on death or transfer on death accounts. Financial accounts that designate beneficiaries bypass probate. Gifting assets during lifetime. Transferring assets before death reduces the size of the estate subject to probate. Working with an experienced Long Island wills attorney. Estate planning involves important legal decisions that impact both asset distribution and privacy. A wills attorney can help navigate New York's estate laws to ensure that your wishes are carried out while maintaining as much confidentiality as possible. Without proper legal guidance, errors in estate planning could lead to unintended consequences, making financial and family matters public. Schlessel Law PLLC is dedicated to helping individuals and families create effective estate plans that align with their goals. Whether you need assistance drafting a will, setting up a trust, or ensuring your estate remains private, our law firm is here to help. Contact Schlessel Law PLLC at 516-574-9630 or visit us at 34 Willis Avenue, Suite 300, Mineola, New York, 11501, United States to discuss your estate planning needs.